defendant arranged for, attempted to arrange, or prepare for child abusive activity with a 16-year-old victim. Offered the victim $25 to allow defendant to insert his fingers into the victim's anus while he masturbated, and later offered the victim $100 to engage.
What happens when misplaced power meets predatory intent? In this courtroom, we are not just watching a case, we are witnessing a clash between law, morality, and public safety. A teenager, a hidden police operation, and a man who believed money could bend boundaries set the stage for a chilling legal confrontation. As Judge Muddleton takes the bench, the room carries tension heavier than any charge sheet. Was this a moment of entrapment, reckless judgment, or deliberate exploitation? The prosecution frames this as a calculated attempt to manipulate a minor, while the defense struggles to construct a credible narrative. Stay locked in. This case will test your sense of justice.
People versus Michael Joseph Miller, file 252189FY.
Good afternoon, Your Honor. Brittany Johnson on behalf of the people, P83513. Good afternoon, Your Honor. Sarah Kraus, P81830, appearing on behalf of Michael Miller, who is going to be entering the courtroom
Okay.
right now.
Good afternoon. So I am sitting as the 23rd judge here, 23rd District Court judge for my good friend Judge Shackelford. So I know she's inundated right now. Sir, your name?
Michael Miller.
All right, you can have a seat. So we have a preliminary exam scheduled on a count 1 child sexually abusive activity. A count that's a 20-year felony. Then we have count 2, another 20-year felony using a computer to commit a crime, accosting a child for immoral purposes, a 4-year, and then a 10-year communicating with another to commit a crime. So any preliminary matters? Ms. Johnson?
No, Judge.
Ms. Kraus?
No, Judge.
Okay, thank you. Call your first witness.
Thank you, Your Honor. This time I would call Detective Philip Powell.
Okay. Good afternoon, sir. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes.
Could you please state your name and spell your name first and last for my recorder?
Detective Philip Cowell, PHILIPCOLLOP.
COLLOP.
Correct.
Thank you. Have a seat. You may proceed, Ms. Johnson.
Thank you, Judge. Detective Powell, could you just repeat your name for the record?
Yes. Detective Philip Cowell.
And Detective Powell, were you employed
Yes.
by whom?
The City of Taylor Police Department.
And how long have you been with Taylor Police
13
Department?
years.
And were you with them July 24th of 2025?
Yes.
What were you doing?
Working in undercover sting for individuals attempting to meet up with juveniles for sexual purposes.
Okay. And was that an in-person thing, an online thing, something different?
Pretty much online, but eventually returned to in person.
Okay. And do you have any training and experience working on operations such as that?
Worked on them in the past, but specifically as a detective, I work in sexual crimes against children.
Okay. And in this case, were you the individual communicating with the alleged defendant in this case?
No.
Okay. And were you involved in the arrest of that individual?
No.
Okay. Did you ever have occasion to see Mr. Michael Miller?
I did. I completed an interview with him.
Okay. And do you see that individual in the courtroom today?
Yes.
Could you please point to him, tell me something he's wearing?
Right here, gray shirt.
Your Honor, if the record will reflect the witness's identification of the defendant, Mr. Miller?
Record should so reflect.
Okay. And you said you conducted an interrogation with him?
Yes, Miranda interview.
Okay. And did you advise him of all of his rights?
I did.
Okay. Did you go over those in writing and out loud?
Yes.
Did you have him fill out a form
I
to
did.
attest to that?
Yes.
Okay. And did he indicate that he wished to speak with you after being apprised of those rights?
Yes.
Okay. Did he seem under the influence or like he didn't understand or anything of that nature?
No.
Okay. And may I approach with what's the mark as people's proposed 5?
You may.
Judge Muddleton handed you something. Does that look familiar to you?
Yes, it is.
Okay. Is that a fair and accurate depiction of that Miranda form that you filled out with Mr. Miller?
Yes.
Okay. And is there a portion there for him to fill out something from his own perspective?
He initials each statement as I read it, and then he signs the form with his address.
Okay, and then below that, is there a portion for his statement?
There is just a statement after the interview is completed. I ask if he would like to complete a written statement as to events that occurred.
Okay, I'll take that back. Your Honor, if the people would move to admit and publish People's 5.
Any objection?
No objection for exam purposes only.
People's 5 is admitted.
Okay. And you indicated that he wrote this statement at the bottom of this after you had a conversation with him, is that right?
Correct.
Okay. And during that conversation, did he indicate to you that he was at the park that day to meet a 15-year-old for sex?
Yes.
Okay. Did he indicate he thought that was wrong?
Yes.
Did he provide you with the passcode to his phone?
Yes, he did.
Okay. Your Honor, that's all the questions I have for this witness.
Cross-exam.
Yes, Judge, briefly. Detective Cullup, about how long did you meet with Mr. Miller?
For the entire interview,
Yes.
I don't recall the exact amount, but I know probably roughly an hour, maybe.
And during that interview, Mr. Miller started to experience some chest pain, is that right? You don't recall that? Okay. You were informed that he was taken to the hospital after his interview with you, is that correct?
Oh, I did not.
Okay. I have nothing further of this witness, thank you.
Any redirect?
No, Judge.
You can step down. Thank you very much. Call your next witness.
Thank you, Judge. At this time, the people would call Ruby Scott, Taylor Pittsburgh. Ruby. Thank you, sir.
Okay, good afternoon. Can you raise your right hand, please? You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do.
Could you state and spell your name for my recorder?
It is Ruby Scott, R-U-B-Y, Scott, S-C-O-T-T.
Thank you.
Thank you, Officer Scott. Are you employed?
Yes, ma'am.
By whom?
The Taylor Police Department.
And how long have you been with the Taylor Police Department?
About 4 years.
Were you with them July 24th of 2025?
Yes.
Do you recall your assignment that day?
Yes.
What were you doing?
An undercover decoy.
Okay, and a decoy for what?
Catch online predators.
Okay, and so were you talking to people online?
Yes.
When you were talking to those people online, were you posing as somebody who was 15 years old?
Yes.
Start with, were you on the app Meet Me?
Yes.
Okay, and on that app, did you make a profile?
Yes.
Okay, when you made that profile, were you using pictures of yourself?
Yes.
Okay, were they in any way edited, age progressed, age regressed, changed in any way?
Yes.
Okay, how was that done?
It was done with an app,
I'm sorry, with the what?
with an application.
Okay,
I used a child filter. Made
thank you.
myself appear as a child.
And in the profile on Meet Me, did that list your age as 18?
Yes.
And why was that?
Because that is the only age, that is the age that's allowed for me. You have to be at least 18 to be on a dating app.
Okay. And when you were on that app, did you speak with somebody who identified themselves as MJM?
Yes.
While talking to that person on that app, were you talking to other people too?
Yes.
Okay.
At this critical moment, the judge is not merely reacting emotionally. She's dissecting intent, opportunity, and culpability. In criminal law, motive matters as much as action, and here the police sting becomes the decisive variable. The defendant's language, behavior, and negotiation of money are treated as circumstantial evidence pointing toward premeditation rather than confusion. This is not a simple morality tale. It is a textbook examination of criminal liability, mens rea, and public protection. Ask yourself, should undercover operations be seen as necessary shields or controversial traps? The answer shapes how we interpret justice in modern society.
And in the conversation with MJM, did you provide that person a phone number to contact you instead?
Yes.
Do you recall the phone number you used?
I do not.
Okay. And was that the only person you gave that number to at the time?
No.
Okay.
And prior to giving him your phone number, had any of the conversation been sexually explicit?
Prior to that, no.
And did the person you were talking to on the app ask to meet in person?
When we were texting, I believe, he was texting that.
In that conversation, does it say what time your conversation had started?
I don't recall. I
I'll
don't.
hand it back to you. Would that refresh your recollection?
Yes.
Okay. Does that refresh your recollection?
Yes.
What time was that
5:04 p.m.
at? Okay. And you're ready to approach again?
May?
And they hand you two things. I'm gonna do this one at a time. I've handed you people's proposed two. Flip through that, please. Let me know when you've had a chance to look it over. Is that a fair and accurate depiction of the account that you were speaking with?
Yes.
Okay. And in fact, when you had conversations with this account, some of the photos that are here, are those photos that that person sent you?
Yes.
Okay. Here, the people would move to admit and publish people's two.
Any objection?
No objection for exam purposes.
People's number 2 is admitted.
Handed you people's proposed exhibit 3. Just leaf through that real quick, please. That's a fair and accurate depiction of something you've seen before?
Yes.
What is it?
That's my profile.
Now, sir, do you have a chance to look through people's proposed 4?
Yes, ma'am.
And did you look through that before the exam as well?
Yes.
Okay, is this a fair and accurate depiction of the conversation that you had with the person who texted your cell phone number?
Yes.
Okay, and when you were talking to him, did he identify himself as Michael?
Yes.
None of the people would move to admit and publish people's 4.
Any objection?
No objection for
People-
exam purposes.
People's 4 is admitted.
Most of those messages speak for themselves, so now that they're admitted, I'm just gonna ask you a couple questions about that conversation. While you were talking to that person, do you know what time the text conversation started?
Shortly after 5:04 p.m.
Okay, and you said that you believed you were talking to him for about an hour?
Yes.
Okay. Did you all exchange names?
Yes.
Okay, what was the name you used?
Jesse.
Okay, and what was the name the individual identified themselves as?
Michael.
And did you identify yourself as someone under the age of 16?
Yes.
Did you let him know you weren't old enough to drive?
Yes.
Did you also tell him the age of consent in Michigan is 16?
Yes.
When did you indicate that you would turn 16?
In October.
October of this year?
Yes.
And that was a date that had yet to happen?
Yes.
Did you talk about where you both lived?
Yes.
Where did you say you lived?
Taylor.
And while you're having these conversations, where are you physically located?
Taylor Police Department.
And when you were exchanging pictures, do you see the person that was is depicted in the photo sent to you in the courtroom here today?
Yes.
Can you point to him, tell me something he's wearing?
He's wearing a gray dress shirt that's rolled up.
Thank you. Your Honor, if the record to reflect the witness's identification of this defendant.
The record should so reflect.
And in that conversation you had with him, did you make a plan to meet in person?
Yes.
Where were your plans to meet?
Heritage Park.
Okay, you said Heritage Park?
Yes, ma'am.
Is that in the city of Taylor?
Yes.
Okay. In that conversation, did he use words like to describe himself such as horny or lonely?
Yes. Both.
Okay. Did he ask you to fool around?
Yes.
Did you ask what he meant by that?
Yes.
Okay. And do you remember what he said?
He wanted to fool around in the woods. Specified if you want to have sex, I'm down.
I'm sorry, can you keep your voice up? Did you say he said he wanted to fool around in the woods?
Yes, sir.
And what was the second part of your response?
If you want to have sex, I'm down.
And did he inquire with you about this being a setup?
Yes.
Okay. Does he keep talking to you after that?
Yes.
Okay. And did he ask to have these conversations in person instead of just text?
Yes.
And when he asked if you want to have sex, I'm down, did you agree to that?
Yes.
Okay. Did you ask him to bring condoms?
Yes.
Did you do that directly? How'd you say that?
I stated I didn't want to be a teenage mom.
How did he respond to that?
He advised me he already had a condom.
Did he ever ask for any sexy pictures?
Yes.
Did he argue with you about the photos you had sent?
Yes.
Okay. How was that? How did that go?
I told him that I didn't want to send sexy pictures because I didn't like pig collectors referring to men that collect sexy pictures.
Is that something that you learned in your training and expertise in this area?
Yes.
What training and expertise do you have in these kind of cases?
I attended Stopping online predators training by the Libre Press.
Is that in-person training?
Yes,
Okay, how long was that?
3 days.
Did you describe what you'd be wearing for the meetup?
Yes,
And you picked a specific location in Heritage Park?
yes,
Okay, and were you actually in the park when he arrived?
no,
Okay, did you see him get arrested?
no,
The meetup, was that the same day that you were having these conversations?
yes.
That's all the questions I have, Judge. Thank you.
Cross.
Good afternoon, officer. When you were just asked, if Mr. Miller argued with you about sexy photos, that's not true, is it?
Define argue.
Well, that was the word the prosecutor used and you agreed with her, is that right?
He requested sexy pictures, and I told him no.
Well, if by looking at, People's Exhibit 4, would that refresh your recollection as to what you responded? Would that refresh your recollection as to how you responded?
Yes,
You responded by sending a picture, is that correct?
yes,
And that was a picture of you fully clothed, is that right?
yes.
Okay, so there was no argument about that.
He didn't continue after I sent him a clothed picture. He didn't continue to ask for sexy pictures.
Okay, so there was no argument, correct?
Okay, yeah,
Okay. Now, as for getting on the Meet Me app, were you directed to do that by somebody higher up in your apartment?
yes.
Okay. And who was that person?
The detective bureau.
Okay. And were you using at that time your personal phone, department issued phone,
I was using a tablet.
a tablet?
I believe it was an iPad actually.
Okay. Was that issued by your department?
Yes,
People's Exhibit 4, those are screenshots, is that right?
yes,
And those would be something that you turned over to the detective bureau, is that correct?
yes,
Okay, there is no timestamps on these photos, is that right? Or these text messages, the screenshots?
I don't know.
Would looking at People's Exhibit 4 refresh your recollection?
It says 8:04 at the top of the conversation, but there's no actual timestamps on the texts.
Okay, so the 8:04, that would be the time that the screenshots were taken, probably, correct?
Yeah,
Most of the conversation you had with Mr. Miller was innocent conversation, is that correct?
yes,
He talked about his mom, right?
yes,
Okay. And Mr. Miller specifically asked you how old you were, is that right?
yes,
And you responded, are you gonna leave me on read if I'm not 18?
yes,
Okay. And Mr. Miller said no, but he doesn't want to get in trouble, is that right?
yes,
And then throughout these text messages, you're trying to ask Mr. Miller what he wants to do, is that correct?
yes.
Okay. And you keep asking him what he wants to do, is that right?
I don't believe it was continuous, no.
At one point, Mr. Miller asks what you want to do, and you say anything you want, is that right?
I don't recall saying anything more.
If I were to show you People's Exhibit 4, would that refresh your recollection? Throughout this conversation, it's kind of as you're leading Mr. Miller on, is that right?
Sex?
Yes. No? You didn't send him kissy faces?
In a movie that it has a heart and a kissing face, yes.
Right. And you told Mr. Miller, so in that case, you want to tell me what we're gonna do? And he said, walk in the woods and maybe fool around. Is that right?
Yes.
Okay. And then you kept asking him, what do you mean fool around? And he replied, this is starting to sound like a setup. Is that correct?
Yes,
And throughout this conversation with Mr. Miller, you did not send him any photos that were explicit. Is that correct?
correct.
Okay. And he did not request explicit photos from you. Is that right?
Just sexy.
Okay. Okay, I have nothing further, Judge. Thank you.
Redirect,
No, Judge.
you can step down. Thank you very much. Call your next witness.
But I would like to approach with 9 seconds.
Okay. Thank you very much.
Judge?
You have no witnesses, correct?
No witnesses, Judge.
People move to bind over?
Yes, Judge, I would move to bind over and reserve argument.
All right. You agree this is a fact question, don't you?
Well, Judge, I would like to argue bind over on count 1 and the associated count 2.
Okay,
Count 1 is child sexually abusive activity, Judge, and the statute is clear. It indicates a person who persuades and induces, entices, coerces, causes, or knowingly allows a child to engage in sexually abusive activity for the purpose of producing any child sexually abusive material. Judge, that does not fit the facts of this case. I don't believe there was no sexy photos taken. There was no, pornography sent back and forth. This is not somebody who's enticing or trying to entice this young person to create what's basically porn in this circumstance. So I don't believe there was any child sexually abusive activity that occurred here, Judge. So I'm asking for count 1 and count 2 to be dismissed. And I would say it's a question of fact for count 3 and count 4.
counsel?
Judge, I've had this argument a couple of times before, and so I would cite to People v. Willis, 322, Mitch App 579, the 2018 case. And it says that for child sexually abusive activity, there are a couple of groups of people, and that the group that it seeks to prohibit their conduct. And there's the group that is doing these things for the purpose of creating CSAM, and there's people who are doing these things for the purpose of engaging in child sexually abusive activity. That activity is the arranging for of sexual activity with a minor. I think those elements have been met. Looking at the Willis case, in that case, the individual asked a child to come over and engage in sexual acts. And in fact, they never even engaged in the sexual acts, but because he came over and the plans were there to do so, the court said that the court rejected the defendant's claim that it's limited to criminalizing conduct involving the production of child sexually abusive material, and that it includes the category of people who attempt to produce, make, copy, reproduce, or finance any child sexually abusive activity, or child sexually abusive material. And so because that activity is what we are getting at here today, Judge, I believe our elements have been met. And for the coordinating, using a computer to commit a crime, that would follow as this penalty is within the range that is laid out by that statute.
Somebody pull that file, that case for me. Give somebody that can pull it, pull that up in 322 Mishap 579. Ms.
Now the courtroom shifts, and so does the story. As evidence unfolds, contradictions in the defendant's testimony begin to unravel his credibility. Body language, evasive answers, and legal maneuvering reveal more than any confession could. The judge's firm tone signals that accountability outweighs sympathy in cases involving minors. This is where the audience must reflect. If you were on that jury, would you prioritize rehabilitation or punishment? Would you consider intent over circumstance? The law is rarely black and white, but this moment pushes us closer to a moral conclusion.
Kraus, do you have any response?
Yes, Judge. The statute is very clear. She's citing a Court of Appeals opinion case, which I have not seen. I would like a chance to look at it too.
We'll provide you a copy.
But the statute is clear that this involves the making of material or the producing of material. That was not the case here, Judge. It's not as if we heard testimony that.
Let me stop you. Tell me a little bit more about the facts of that case.
Yes.
So in Willis, the defendant spoke with the victim outside, asked the victim his age, and then invited the victim into his apartment. While inside the apartment, the victim sat on the couch. The defendant put his arm around the victim, used his cell phone to show him a video of some pornography, offered the victim $25 if he would allow the defendant to insert his fingers into the victim's anus and masturbate on the victim. The defendant later offered the victim $100 to engage in sexual intercourse. The victim declined both offers and left. And the court does go into,
And there was no specific mention about him videoing it?
correct, Judge, there were no allegations of child sexually abusive material being made or attempted to be made in that case.
What did the court say specifically?
The court said the use of the disjunctive or in the second and third categories, so those people who arrange for, produce, make copies, and then those people who produce, arrange for, or make copies for the purpose of creating CSAM, those are two separate groups, and that the statute delineates child sexually abusive activity and child sexually abusive material as two separate things, and that the or indicates that the persons who arrange for or attempt or prepare to arrange for child sexually abusive activity face criminal liability. And that cites to People v. Adkins, which is 272 Mish App 37, 2006 case.
All right. Here's what I'm gonna do. I'm gonna go on to this arraignment. I'm gonna ask you guys to pull that case for me, please. And provide a copy to Ms. Kraus. And I'll do the arraignment and then we'll come back on this case.
Thank you.
Okay.
Judge, I'm sorry. We need to handle the sentencing really quick. It's not really sentencing. We just want to put him into treatment. I have the probation officer here and the attorney.
Okay.
Thank you so much, Judge. He's on Zoom from Wayne County.
Okay. But I'm not.
Mrs. Laura,
All right.
are we bringing Mr. Purdue back in the courtroom?
No, well, that's for Mr. Or, yeah, it's OWI.
People against Michael Joseph Miller. Again, this is 2521895Y. All right. I have everybody here. Ms. Johnson. And I have Ms. Boyer. What would you like to say in this case here? Anything else?
Yes, Judge, I would just like to point out the facts and circumstances in the Willis case that Ms. Johnson is using on behalf of her argument are very, very different than what we have in this case.
Why?
The,
Because he showed him a video first?
there was a video shown, they were both in the same room, and he was trying to entice her with money. People's Exhibit 4, we have the decoy officer, and I would urge you to look through these text messages, Judge, because she's the one bringing up the age of consent. He's not making any sexual comments or innuendos. She brings up the age of consent. It's as if she is soliciting him to try to come to her. When you read the text messages in a whole, Judge, and I just don't think this charge can stick as it relates to a probable cause standard.
Judge, honestly, that fact cuts the complete opposite direction. That was could have been construed as a last minute warning of, hey, you're talking to somebody who's under the age of 16, the age of consent in this state is 16, and the sexual based nature of the conversation continues. The defendant agrees to meet up with someone who thinks he's 15. He shows up.
I agree with you. I'm sorry. I mean, when I first, at first blush, when you were arguing it, I tended to think you had a good argument. But I'm just going to point to the court's, this is on page 579, it looks like. My glasses here are not doing well. Turning to the sufficiency of the evidence to support defense conviction, we conclude that viewed in a light most favorable to the prosecution, the evidence was factually sufficient to show the defendant arranged for, attempted to arrange, or prepare for child sexually abusive activity with a 16-year-old victim. The evidence showed the 52-year-old defendant invited the 16-year-old victim into his apartment, showed him a pornographic video of two men engaging sexual intercourse, offered the victim $25 to allow the defendant to insert his fingers into the victim's anus while he masturbated, and later offered the victim $100 to engage in sexual intercourse. This was sufficient for a rational trier of fact to find that the essential elements of child sexually abusive activity were proved beyond a reasonable doubt. Prosecutors was not required to prove that the defendant's conduct involved the production of child sexually abusive material. So, I mean, it is a closer call, I'll grant you, but in light of this case law, I'm going to go ahead and bind the defendant over on all counts contained in the complaint and warrant. The arraignment on the information will take place 1 week from today, which is.
I don't get 2 weeks, Judge, he's out of custody.
Oh, I'm sorry. Okay.
October the 20th.
My apology. What is it?
It's October.
October the 20th.
October 20th? They're putting them out that long? That's 4 weeks. Wow. Okay, we do 2 weeks. All right, that's good enough. So, I'll go ahead and indicate he's supposed to be there October 20th at 9 a.m. on the charges contained in the complaint warrant. What is bond set at right now?
There was a monetary bond, Judge. Mr. Miller is also on a GPS tether, which I would like to address.
Well, hang on one second. What is the bond? Is it $150, Cashier?
No,
I didn't think so either, but that's what it says here. Oh, no, personal bond with GPS tether.
yes.
Do we have, you guys put bond copies of bond sheets in here or not?
She should have like her bond things written on the inside.
All right.
Just do the conditions.
Yeah. Okay. You cannot leave the state without consent. No one supervised contact, sir. No one supervised contact with any child 18 years or younger. I should say under 18. You're not to be on the internet. There's drug and alcohol testing. Was there any evidence that he was involved in drug use or alcohol use at the time of this?
No, Judge.
I'm going to go ahead and continue that though. 8 a.m. to 8 p.m. curfew, must have his GPS tether, no alcohol, no drugs. And that's it. And I will continue the bond, which was, I'm going to make it, can somebody tell me what the bond was?
$150,000 personal, Judge.
Okay, $150,000 personal bond is continued subject to those conditions. No contact with the victim or her family members. You understand that?
Yes, sir.
All right.
Judge, I just want to address one thing about bond. Mr. Miller does have children who he has supervised visits with. They do reside in Genesee County. Apparently it's been an issue with his tether agent that he's not allowing him to go to Genesee County.
Why?
I don't know. So I am asking for the court to make an amendment to the GPS tether that he can travel to Genesee to see.
How can they,
I asked the same thing, Judge.
how can they do that? They get to override judges. What is this, a sheriff from the tether unit?
Yes,
They get to override judges' decisions now, huh? I mean, I'm not comfortable with him not having the GPS tether.
right, and
The only thing I can tell you is if when you go downtown, I would ask the judge to call over to the tether unit or have a secretary call, or maybe we can call and say, hey, there should be no problem with him going to Genesee County unless he's violating some bond on some other case. I mean, I don't understand some of this, but I just do what they tell me. Okay? But I'm not gonna take the GPS tether off, so.
right, I wasn't asking for it to come off. I was asking for him to have permission to go to Genesee.
Well, I don't have any problem with you. I just said he just can't leave the state without consent unless he's violating terms of his GPS tether. I mean, what is this? I don't either. One of these days. Well, that's all I'll say. Thank you very much. Nice to see you. Nice to see you too, Ms. Johnson.
Nice to see you.
Take care.
And Magistrate Cremona, always a pleasure.
All right.
Thanks for watching. Stick around longer and click the highlighted videos to your right. See you there.
In the end, this case stands as a stark reminder that the justice system exists not only to punish crime, but to deter future harm. Judge Muddleton's ruling reinforces the principle that adults bear full responsibility when crossing ethical and legal boundaries with minors. The police operation, while controversial, highlights the state's commitment to proactive protection rather than reactive punishment. Beyond this single courtroom, the broader message is clear. Vigilance, accountability, and rule of law must prevail over manipulation and misconduct. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.